Laws for thee, not for me. A U.S. judge, Michael Truncale, has ruled against Brook Jackson, the Pfizer whistleblower who was fired shortly after exposing alleged violations from the pharmaceutical giant. We're going to discuss what happened here. And so from TrialSite News, I am Adrian, and our episode is starting right now. So, just a few days ago, back on March 31st, United States District Judge Michael Truncale ruled against Brook Jackson, the Pfizer whistleblower, who was suing that firm and its clinical trial subcontractors on behalf of the U.S. government for substantial irregularities to their clinical trials practices. The opinion in USA v. Ventavia Research Group, LLC, Pfizer Inc., and Icon granted the motion to dismiss with prejudice Brook Jackson's presentment and false record claims, which is the heart of the case. Judge Truncale also dismissed a retaliatory firing claim without prejudice, meaning this claim could possibly be refiled under a different legal theory. For a motion to dismiss, the court assumes as true the facts alleged by the plaintiff Brooks, and then decided whether the facts amount to a legally cognizable claim. For example, in one aspect of this ruling, Judge Truncale noted that the COVID-19 vaccine contracts at issue involved the Department of Defense. He noted that the case was brought under the False Claims Act, or the FCA, and pointed out that the U.S. government, who is supposed to be the beneficiary of the case, had already filed papers requesting that the motion to dismiss be granted. In a key fact, the judge noted that Operation Warp Speed was an interagency partnership between the United States Department of Defense and the United States Department of Health and Human Services that coordinated federal efforts to accelerate the development, acquisition, and distribution of a COVID-19 vaccine. In July of 2020, while Pfizer's vaccine was still under development, the Department of Defense entered into a contract, the project agreement, with Pfizer, under which Pfizer would deliver 100 million doses of FDA-authorized or approved vaccine to the government on a fixed price per dose basis, in accordance with a statement of work. Now, Brook Jackson was a regional director for 2 Ventavia testing sites for a total of 18 days in 2020. An investigational site network, Ventavia was hired by Pfizer's CRO Icon to help conduct the Phase 3 COVID-19 vaccine clinical trial. Jackson's complaint stated that this firm, quote, falsified information when conducting quality checks or otherwise hid protocol violations from Pfizer and Icon. Violations alleged include pregnant women were included against protocol, failing to test a participant for COVID-19 prior to vaccinations, and allegedly falsifying this participant's source document by crossing out a question about why vaccination preceded informed consent and added a comment that the informed consent time was incorrect. Other violations of protocol included enrolling employees and family members in this trial, and examining married couples or groups of friends at the same time instead of individually. Furthermore, Brook Jackson alleged unblinding errors. Specifically, there were 3 incidents that unblinded or had the potential to unblind staff and participants. Here's some of the examples. First, she alleged that the containers marked with numbers that would enable someone to determine whether a participant received the vaccine or placebo were left out in the open. Second, on one occasion, Jackson alleged that she was inadvertently unblinded after receiving an email containing participant numbers and dosing information. And finally, third, she alleged that randomization documents, which reveal whether a participant received a placebo, were improperly placed in the charts of 1,200 participants. Other violations included when a freezer containing vaccines was allegedly unplugged and moved, resulting in a temperature excursion. And Ventavia allegedly reported the excursion to Pfizer late, in violation of the protocol requirement that excursions be reported as soon as discovered. In addition to this, though the protocol required thawing the vaccine for 30 minutes prior to administration, Brook Jackson declared that at times Ventavia employees only waited 20 minutes and held the vaccine vials in their hands to expedite thawing. This would be an obvious violation of quality. Brook Jackson also alleged that the firm violated protocol by taking participants' vital signs or administering the vaccine before obtaining their informed consent. And the firm is alleged to have hidden these violations by falsifying source documents to make it appear as though its employees had obtained informed consent before taking the vital signs or administering the vaccine. Ventavia, according to Brooks, also violated trial protocol by allowing improperly trained or unqualified employees to administer the vaccine. Other violations included that the firm administered the second dose of the vaccine to participants outside of the protocol-mandated 19 to 23-day window, and that vaccinators allegedly sometimes used the wrong size needle to administer the vaccine. And on at least 4 occasions, Ventavia employees allegedly used 1.7 milliliters instead of 1.2 milliliters of sodium chloride to dilute the vaccine. Jackson alleged that the firm falsely informed ICON that the discrepancy was due to a transcription error. She also stated that the trial protocol required placing participants under medical supervision for 30 minutes after receiving the vaccine, but that some participants were supervised for less than 30 minutes and/or supervised by a non-medically qualified employee. Now, the complaint also stated that there were protocol violations relating to adverse event reporting. Jackson claimed that Ventavia failed to report all such events, including serious adverse events, to Pfizer and ICON. Jackson also alleged that Ventavia failed to maintain accurate and complete documentation throughout the trial. She broadly asserted that Pfizer and ICON turned a blind eye to this inadequate record-keeping despite obvious warning signs, and that these sloppy documents were included in Pfizer's trial results. All of these factors make for a highly troubling quality signal. Now, 4 specifics were asserted dealing with inaccurate or missing time entries. A Ventavia employee, for example, changed blood pressure readings in participant source documents. There was a delay in a system to track COVID-19 symptoms among participants, and a principal investigator signing off on records for folks who were in fact examined by other medical staff. In listing these ethical problems, Jackson included that Ventavia allegedly breached its ethical obligations by providing unauthorized compensation to trial participants in the form of gift cards without IRB approval. Now, the corporate defendants made a key issue that the Federal Acquisition Regulation, or FAR, requirements relating to manufacturing standards do not apply here. Defendants claim that due to pandemic-related exigencies, the project agreement was not a standard federal procurement contract, but rather a prototype agreement. Such a prototype agreement falls under the Other Transaction Authority of the Department of Defense. These agreements are not subject to FAR, which is the primary regulation otherwise used by government agencies in their acquisition of supplies and services with appropriated funds. Quoting another case, the judge noted that other transactions are legally binding contracts that are generally exempt from federal procurement laws and regulations. The judge, in rejecting Jackson's contention that the vaccines were not primarily for the military, said that the fact that both military personnel and civilians received the vaccine does not indicate that acquiring the vaccine was irrelevant to enhancing the military's mission effectiveness. Citing the U.S. Supreme Court, Truncale noted that complex, subtle, and professional decisions as to the composition, training, equipping, and control of a military force are essentially professional military judgments. So it is difficult to conceive of an area of governmental activity in which the courts have less competence. This court will not veto the Department of Defense judgments concerning mission effectiveness during a national emergency. And the judge went on to point out that the deal between the Army and Pfizer didn't regulate the conduct of the clinical trials. How convenient. This is a troubling conclusion. It would appear that the judge dismissed this case not because Ms. Jackson's claims were incorrect, but rather a higher order level of complex decision-making rationale directed his decision. Like with so many observations during the COVID-19 pandemic, lots of the typical and traditional measures applied to drug and vaccine research were discarded and just simply didn't apply. Safety for the public be damned. It was an emergency, people. Nothing to see here. We seem to be living in an age where laws and regulations just don't seem to matter much, unless it happens to align with the wants and desires of those in power. How can the American people trust their government, let alone the pharmaceutical industry, when it seems that at every turn, safety protocols are abandoned, and freedoms are suppressed. The rationale for why we should ignore these actions is always the same. It's for the greater good, you see. Always the greater good. And that, my friends, will bring our episode to a close once more. For more content like this, be sure to check back to this channel daily, Monday through Friday, or for written articles published every day, 7 days a week, feel free to visit us at TrialSiteNews.com. And as ever always, my friends, thank you so much for joining me on the program today. From TrialSite News, I am Adrian, and I will see you all next time.